Hi, everyone. Thanks for joining us at our webinar today. I'm Scott Thompson, head of the IP group at Lippis Mathias, and I will introduce our agenda and our speakers, and we will go from there for the next hour. So next slide, please. So I'll start out with a brief welcome, and then Colleen is going to talk about U.S. trademark applications and some nuances. We'll go to Matthew Aspel, who's sitting here with me in New York. We'll talk about comparative aspects in the U.S. practice. Then up to Buffalo with Andrew Olick in our corporate group for corporate considerations. Out to Denver, Colorado for Dave Johnson to talk about operating challenges, privacy marketing, social media. And in Buffalo, Beth McLaren will talk about immigration hurdles for employees coming into the U.S. So next slide, please. So Lippis Mathias is a 200-attorney nationwide U.S. law firm. We've got 30 IP dedicated attorneys. Our practice includes patents, trademarks, copyrights, trade secrets, unfair competition, data privacy, counseling, filings, prosecution, litigation, basically the whole gamut. Now, we also work closely with the other 170 lawyers in our firm that cover tax, corporate, immigration, healthcare, labor and employment, and related areas of the law. Next slide, please. So just to pose some questions that my partners are going to answer today. You have a client that comes to you in whatever country you're sitting in and says, thank you for letting me know that trademarks are territorial and I need to think about filing in every country where I want to use my brand. So now I'm ready to go to the US and get an application filed. So can you tell me, can you file it yourself because the USPTO is online? Do you tell your client, it doesn't matter whether you're doing business in the US or not, or own a foreign registration, you can file very simply in the US. Do you ask your client how it will do business or interact with US customers? Do you advise your client that since its website is accessible to those in the US already, there's nothing else that they need to do? Next slide, please. Do you agree with your client when he tells you or she tells you that data it collects from those in the US is really key and they can do whatever they want with the data? Do you inform your client that it can send its employees to the US for business as often as they need and they can stay as long as they like? And depending on how you answered all of these questions, do you like to take huge risks in life and answer all these questions yourself without the assistance of US counsel? And these aren't questions that we made up. These are actual questions that have been posed to all of us from attorneys around the world. And we want to go through some scenarios and examples to provide you with details. So I'm going to turn to my colleagues for the answers to all of these questions. If you in the audience have any questions, feel free to use the chat box to type it in, and we'll try and save a few minutes at the very end before we hit the 1 hour to answer your questions. So now I'm going to turn to my colleagues, and I'm going to start in Cleveland, Ohio, with Colleen Flynn-Goss.
Hi. First of all, thank you all for joining us this afternoon, evening, morning, wherever you are. I hope it's not morning for you. Just very briefly, I practice solely trademark and copyright law. I concentrate on prosecution and enforcement at the Trademark Trial and Appeal Board level. I will do some transactional work with respect to licensing and coexistence agreements and consents, and reviewing corporate documents, which Andrew may talk about later. But I have absolutely no technical background and can barely spell patent. So I am just going to take you through your options for filing applications in the US. And it's probably not the most exciting part of this presentation, but you need to know. Next slide, please. So there are 5 bases for filing trademark applications, not for registrations, for filing the applications. So there's actual use of the trademark in commerce in the United States. There's a bona fide intention to use the mark in the United States. You can file based on your foreign application in your client's home country, as long as the application that you're basing your US application on is less than 6 months old. You can base it on a foreign registration, and there's no time limit there. And of course, you can always designate the United States in a international registration under Madrid Protocol. Next slide, please. It is important to note, I should back up there, it's important to note that any applicant not domiciled in the United States is required to be represented by a licensed US attorney. So that Scott's first comment about it's online so I can file it will not work for you. You won't even be able to file it. One of those first four, if it is a designation of the international registration, your very first office action will be, please appoint a US attorney. So anyway, here we go. Speaking of the extension of protection under the Madrid Protocol, it still requires that the applicant declare that they have a bona fide intention to use the mark in commerce in the United States. The application is examined just like any other application. There is, however, no need to show use in commerce of the mark in order for the US extension of protection to issue. Next slide, please. The next, less simple, is to base the US application on one or more registrations that have been issued in the trademark owner's home jurisdiction, as long as that jurisdiction is a party to a convention or treaty to which the US is also a party, or it extends the same reciprocal registration rights to US citizens. I actually looked, and there are only about 10 countries throughout the world that are not party to some convention or treaty that provides for this, for the reciprocal rights. And I guarantee you that no one on this call is in any of those jurisdictions, because I didn't even know where half of them were. For foreign registration, you just simply need to submit a photocopy of your foreign registration. It also requires a declaration of a bona fide intention to use the mark in the United States. However, you do not have to show use in commerce in order for the US registration to issue. Next slide, please. You can file based on a foreign application, as long as it was filed within 6 months of your US application. It again requires a declaration of a bona fide intent to use. This basis is for the application only. It will switch to the previous 44E once the foreign registration, resulting foreign registration issues, and you just submit a photocopy of it, and along with the registration particulars. And again, you will not have to show use in commerce. The other benefit of doing this is when you file your application in the United States, even though it may be exactly 6 months later than the foreign application date, your effective date of first use in the United States is that, effective date of first use, I guess it's true. It's your filing date in the US is the same as the filing date in the foreign application. Boy, sorry, stumbled through that one. Next slide, please. Then you can, if you are unable to do any of those, then you are stuck with the national applications in the United States. And again, the intent to use is a basis for application. It is not a basis for registration. You will have to establish use in commerce before and prove it before your registration will issue. But it is nice that it gives you the ability to file before you've used the mark, and your date of filing is considered your effective date of first use in the United States. And as I think Matthew will talk about common law rights, that makes a difference for you because rights in the United States are based on use in commerce, and this date pretends that you've already used it. Actual use speaks for itself. You file an application and provide information about date of first use and provide specimens of use. And once it successfully gets through examination, it will go straight to registration after publication. Next slide, please. All right, I'm gonna just throw this out here. This is something you have to, that every single application, and actually any filing after that, maintenance documents, whatever, will have this same declaration. And I'm not real fond of the fine, imprisonment, or both part of it. So just keep that in mind. Next slide, please. And I raise it because, as I mentioned, use in commerce is the basis for trademark registrations in the United States. Use in commerce, as I said, central to obtaining registrations in the United States. Use in commerce is when it's placed on the goods or packaging for goods, point of sale displays, or for services when it's used in advertising or in materials used in rendering the services. These sales have to be in the ordinary course of business. So you can't just send a product to me gratuitously and hope that, and consider that use in commerce in the United States. Although anything you want to send, I'll take. The idea is the public or relevant consumer has to be exposed to the mark. And keep in mind that when you're trying to find the specimens of use for goods, advertising material will not be considered use in commerce for goods for the most part. There are some exceptions. It is considered evidence of use for services. Next. Oh, okay, that leads me to this. So the trademark owner makes that earlier declaration, as I said, and it in the applications, and it's also in the maintenance filings. And if that declaration is false, it can present all kinds of headaches, and the worst of which is that your client could lose their registration. So I'm going to quickly run through 3 of those headaches you can encounter. In 2017, the U.S. Patent and Trademark Office started randomly selecting declarations of use filed in the 6th year or with the renewal. And the examiner then asks for 2 additional specimens of use for other items listed in each class. If you cannot provide those, then you have to provide evidence of everything you can do, you can provide use for in the list of goods or services. If you can't, you end up, as I said, losing your registration. In 2021, the Trademark Modernization Act became effective, and this provides 2 new avenues to cancel registrations for marks that are not in actual use. So these are the faster and less expensive alternatives to bring in a cancellation action before the Trademark Trial and Appeal Board, which can go on for a couple years. The first is the expungement proceeding. You request, it's for when a mark has never been used. And these can be brought at any time following the 3rd year after registration and before the 10th year after registration. The other is a request for re-examination petition, and this is for marks, excuse me, excuse me. This is for registrations where the mark has not been used on some or all of the goods at the time of filing the use-based application or the claim date of first use. This can be filed at any time, not later than 5 years after the date of registration. This does not apply to the applications based on foreign registration, foreign application, or under the international registration. However, while it may not be required for use, may not be required for you to obtain the registrations, you still have to start using it, Mark. And it's generally within 3 years of registration. to avoid cancellation based on abandonment. I hope I gave you a little insight into your options in filing in the US. If you have any questions, we can address those at the end of the presentation. Now I will hand this over to Matthew Asbell in New York.
Thanks, Colleen. So I'm Matthew Asbell. Colleen and I have very similar practices that overlap. So I do a lot of trademark prosecution, some enforcement and litigation work, a lot of work internationally, and then some patent work as well. So I secretly am a science person. Don't tell anybody. Next slide, please. So since Colleen covered the U.S. trademark aspects, I'm going to talk about some things that are a little bit more marginal to that, really more of the comparative aspects of U.S. law and practice that really could apply for a number of different practice areas. And the areas I'm going to cover are kind of what is the attorney's role and the perception of what the attorney's role is. The issue of the United States being a common law jurisdiction, while many of our colleagues from abroad are in civil law jurisdictions. The issue of the national laws and the state laws in the US and how they overlap, as well as the attorney licensure in those states. Aspects of expectations regarding client service that are different in different jurisdictions from different views. Some fee structure discussion, and then lastly, once you've instructed this US trademark application, recognizing that there may be other things that we want to pursue beyond that, whether it's other trademarks or other forms of intellectual property, or it's corporate law issues, domain name issues, privacy issues, immigration issues, and the like. Next slide, please. So on the issue of the attorney role, what I've been told from a lot of my colleagues from other countries is that in many countries, the role of the lawyer is to know the law and be able to recite what the law is. And often, and also to explain what the law means, but often it's not necessarily to be the strategic advisor or navigator to help the client achieve a goal. And that's more so what we in the US consider our roles to be. So yes, we do need to know the law and we need to explain it, but really we have to help our clients figure out how do they achieve the goal that they want to achieve? How do we get around or through the issues that we're gonna face? Sometimes our role can also be as a facilitator of cost efficiency. That is recognizing when there are alternatives or less expensive routes, and helping and aligning with our clients and helping them to know those options. Sometimes clients don't know necessarily to ask, and at least I see it as my role to let them consider options that might be more feasible for them when I know what their situation is. Next slide, please. So the US is a common law jurisdiction, unlike most countries around the world that are civil law jurisdictions and the laws are all written out for them. And in common law jurisdictions, particularly in the US, right, our laws, we have some statutes, and we have regulations underneath those, but we have a lot of law that's formed by the courts. And so that law is ever changing. We also have a tradition of recognizing rights that arise at common law, such as rights in trademarks that arise from use. And because of that, when a client wants to file a trademark application or to use a mark in the US, we have a much more expansive searching than most countries require. Now, we have many clients who will not seek to do a search at all because either they've been using a trademark for a really long time, already in the country, because they're willing to accept whatever those unknown risks are, and they'll deal with them if they happen, or they don't have the budget, whatever it may be. But there are many who will go the other end of the spectrum, which is what we typically recommend, which is a full search. And a full or comprehensive US search really is looking at not only the federal and state trademark registrations that might be out there, but also, are there people with a similar business name, a similar domain name, a similar social media handle? Are there people out there using that trademark that would have rights to it and could stop your application and could or sue you for infringement arising from their common law use. Now, when clients can't afford those more expensive full searches or comprehensive search, or they don't have the time to wait, or for other reasons, they may say, well, I want to search, but I don't really want to do that full expensive, extensive screening. So let's do a federal screening or a federal and state screening. Just tell me what's registered. And I'll typically do them in either of two flavors. One where I just say here on their face are the ones I found and they're a problem. That's what I would call a cursory screening. Or no, let me look into them and see maybe they can be canceled. Maybe they already are canceled or they're about to be, and advising the client a little bit more based on what's registered. But it's not sufficient to really evaluate the availability of the mark. Now, because there are common law rights in the United States, and our laws are determined in part from what the courts determine, there can also be an option of advising a client not to pursue a trademark registration. And sometimes that's in their best interest because of what's out there, and whether there's a risk of a lawsuit or another way they can avoid a problem, particularly if they've picked something that's highly descriptive or generic, as an example, and someone else or somebody else owns rights that they're trying to not be found by. We also could use, what's it common law to really carve out ways in which parties can coexist peacefully and resolve issues between them. And then we recognize that since the law can be formed by the courts, that however the law stands today does not necessarily mean that that's how it's going to be. And we can challenge those laws and try to innovate. And I think Dave Johnson's going to give us an example a little later on of how that's being done in relation to ways people track you on websites. We will go to the next slide from here, please. Just 1 second. This is the peril of doing calls like this in your office. So the next issue is that of federalism and attorney licensure. We're in the United States, and people think of us, we are a country, but we are made up of 50 states as well as a number of territories. And the attorneys who work here are licensed in those particular states and admitted to particular courts. So even though intellectual property rights are national, sometimes there's a reason why you want an attorney who's in a particular place or who's licensed in a particular place. National IP rights, a trademark in particular, right, could be filed by any attorney who's licensed in any U.S. state. But there would be other reasons why you might need to know where your attorney is based or if they're licensed there. So some of those instances might be when someone's only using a trademark within a particular state. Another is where people are using it within Puerto Rico being a territory of the United States, recognizing federal trademark rights, and yet the courts tend to prefer that people have Puerto Rican trademarks registered for enforcement purposes. Litigation generally can be important because it might matter where the attorney is licensed and where they're admitted in what courts. Now we can get temporarily admitted as pro hoc vice is what that's called in order to deal with the case, but sometimes you have more expense because you have a need for local counsel in a particular place. There are industries such as cannabis that also have different rights and different laws surrounding them as a result of the different states. Cannabis is illegal federally, but legal in several US states. And because of that, it's not possible to, at least in most instances, get a trademark registration for a cannabis dispensary or cannabis products in most instances. It is possible to get a cannabis trademark registration in a state which allows cannabis. There are also different laws regarding sweepstakes and lotteries. There are laws that differ in different states regarding the rights of publicity or name, image, and likeness rights. And as Dave will talk about, different state laws regarding privacy and personal information. Some different other practice areas have localized requirements while others don't. But you have to recognize that and think to ask. Next slide, please. So there are differences in client service expectations. There's generally what I want to get across on this slide is that there's a general perception about US lawyers, and particularly those of us in New York City where we are today, that we're unapproachable, inaccessible, don't care about you, only want all your money, etc. And I'm here to dispel those myths. I will use WeChat or WhatsApp and communicate with clients. They can text. We try to be accessible. We try to cater to their needs and align with their issues and their expectations. But you have to make those expectations known. So I invite you to do that when you reach out to your lawyer. Let's go on to the next slide in the interest of time. So with how we charge for things, right? Sometimes, I mean, the most common thing in the US is the mighty billable hour. But a lot of people in other countries don't like that or are not used to that. And so there are alternative models where you have contingency fees or success fees. There are models where you can say, I'll charge a fee for this entire process, assuming that nothing bad happens. Or you can have fixed fees at each step, or we can have caps. That might be capped phases in a litigation. We're not going to charge more than this much for this part of the litigation, or a monthly cap. Anything that goes beyond that monthly cap for this litigation, we're just going to punt to the next month as a way to avoid the ups and downs that people struggle with from the hourly rate. Next slide, please. And I guess the last point I'd like to make is that, you know, if you come to the US or you're looking to come to the US with a US trademark application, that's fine and good. Often there will be other trademarks to be considered, maybe even trade dress, and there can be other IP rights to be considered. And we don't necessarily know, unless we know our client well, or our client tells us, or you tell us, right, of the interest and the willingness to consider those other options. Sometimes they can be less expensive, sometimes they can be more powerful. And so really considering that can be important. Same thing with regards to name, image, likeness rights. There's all sorts of ways in which you can supplement those once you've obtained registrations, like filing and customs, should be monitoring applications and uses and other things, corporate names and domain names. We have regulatory laws, particularly to certain industries like finance, healthcare, food and beverage. And then we, of course, in a firm like ours, a general practice firm where there are people in other areas, as we're going to hear shortly from Andrew Olek, we have corporate lawyers, immigration lawyers, and all sorts of other lawyers that have expertise in particular areas that are relevant to coming into this country, independent of the trademark registration process. And with that, I will pass it on to my colleague, Andrew Olek.
Thank you, Matthew. My name is Andrew Olek. I am a counsel in our Buffalo office in our corporate group. I do a little bit of IP work, specifically trademark work. But today I'm here to talk about the corporate considerations for if you're looking to expand your business into the US. Next slide, please. So you've decided you want to take your company into the US. Typically, I would say in almost every instance, that is going to require setting up a entity in the US. And the US has your common entity, a corporation. It also has partnerships and limited partnerships. And then one entity that is somewhat unique to the United States is called the limited liability company. And each of those entities come with different formalities in terms of management and in terms of what you need to file with the state agencies, but then also what sort of documents you need, whether they're bylaws, whether they're operating agreements. But before you decide which entity you're going to file, you also need to look into the tax consequences. There are some countries that do not have, based upon the tax treaty they have or do not have with the United States, some of our US entities are not recognized by those countries and therefore could create negative tax implications for the ultimate owners of the companies. Canada, for instance, does not recognize our limited liability company. So typically for a Canadian company looking to expand into the US, we set up a series of corporations and then, figure out the structure from there. And just like Matthew was sort of alluding to, while trademarks are federal, but there are some state components to that. For setting up corporate entities, all of them are on a state-by-state basis. So each state has their own requirements. Typically, they are more or less the same. You file some type of certificate with the state agency, you pay a filing fee, and then you're ready to go. Some of the state agency states do have what I would call nuanced requirements. New York, for example, if you're forming a limited liability company, you need to publish a notice in a local paper for 6 weeks. It's, in my opinion, antiquated, but it's something that is required in order to set up the entity. And so that's another cost that goes on top of setting up the business in the United States. So while you're setting this up and applying with the state agencies, in addition to screening your trademark in the US, you're also wanting, if your trademark is not your corporate name, going to want to do a search for that corporate name, not only within the state where you want to form your entity, but in any state you might be doing business in. And we obviously recommend let's just cover all 50 states and see what else is out there. Because you certainly don't want to get to the US, get ready to launch your company, and find out, well, you can't form your company under that name, or there's already a US entity that's been operating under that name for 20 years. Now, there are workarounds if the analysis shows that, okay, there's a New York company and they're ABC LLC, we'll just call your company ABC US LLC. So it's not the end of the world if there is an identical name, and certainly the more companies that get formed, and if you're forming in states that have a high amount of incorporation and formation, such as Delaware, you tend to run into names that might not be available for the filed name. That does not mean you cannot file an assumed name or do business as whatever your desired name is, again, assuming that search result comes out clean. And so just know that if you're operating in, your home country, that does not mean that you can automatically operate under that name in the US. Again, we'll conduct a search and we'll let you know, what the results would be and how to proceed. Next slide, please. So in addition to where do I want to form and incorporate my company, we should also discuss, are you going to hire employees? Are you going to have any physical address, purchase real estate, lease real estate? Because for each of those, and it depends on the state, what actually constitutes doing business in a state, a lot of those employees, real estate, will constitute your doing business in that state. So if we were to form the entity in Delaware, but we're going to lease real property in New York, we would then need to not only form your company in Delaware, but also qualify it or submit a foreign filing so that you're registered to do business in New York State. So those are all considerations too. Sometimes, although Delaware is a popular one just because it has well-established laws around corporate structure, Nevada is another popular one. Sometimes we just say, well, you're only going to be in New York. We can live with New York law, so we'll just set the company up in New York. So all of those things are sort of considerations before you launch in the US. And the more time we have to sort of discuss them with the client, the better, because it's never fun when the client says, well, we need to launch in the US next week, and we've not thought at all about how we're going to structure that US entity. So the other thing that comes up a lot of times with companies coming into the US who might not have individuals in the US, right? They might just be setting up and operating the US entity from their home jurisdiction, is that how do we get a US bank account? So we would get a tax ID number, but also a lot of US financial institutions are starting to require an actual address in the US. If you do not have one, are not going to lease properties, there are some workarounds so we can get you an address so that you can open a bank account and start conducting your US business using that bank account. And then I talked about this when I started, but just overall structuring, right? For some companies, it might make sense where if I have a manufacturing division and I have a shipping division, we're going to structure those in two different US entities just to keep them separate and apart, sort of separate our liabilities. And it's a similar discussion around intellectual property. If you're going to do that, do we need any intercompany licenses for intellectual property? or is, you know, our main US entity going to own the intellectual property? And how do we go about protecting that? You know, which entity registers the trademark, the copyright, the patent? One other thing I will add, it's not on the slides, but it's a new requirement that went into effect in January of this year, is what's called beneficial ownership filings. So for any new entity formed in the United States, any individual owner that owns more than 25% of that company needs to submit either their passport or some other form of government identification into a portal. This is not a public portal. It's managed by the federal government, but the federal government's thought is we'd like to know, because a lot of times the structuring, you just have holding company after holding company, and it's, you know, we have no idea who owns the actual company. So this is for the federal government's records to say, okay, we at least now know and have a record of the ultimate individual owners of these entities. So that's just another requirement, something to sort of alert people to, that they are going to need to submit that documentation. The fines for not doing so right now, although enforcement is questionable as to you know, if and how rigorously it's going to be enforced, as there are some lawsuits pending against this legislation. However, fines right now are $500 a day for failure to comply. So it is lots to consider when forming a U.S. entity, and that's just forming it. Then once you actually get it formed and start operating, there's a whole host of other potential laws and regulations that apply, and my colleague Dave Johnson is going to talk about those.
All right, well, thank you, Andrew. Can we advance to the next slide real quick? All right, so my name is David Johnson. I'm a partner in the intellectual property practice here, but I also work on a lot of adjacent issues to intellectual property, including privacy, marketing, advertising, social media, and entertainment law issues. You know, as we've heard so far during the presentation here, at some point you're going to want to use these trademarks and sell your products in the United States. Use is an important part of maintaining the trademark rights, and of course it's a big part of obtaining profits for your clients. So, you know, they're going to want to know what additional operating challenges they'll have once they start using. Some of those include our patchwork of state and federal privacy laws, marketing and website issues, and social media compliance obligations. Next slide, please. So when you begin selling products and services in the United States, personal data collection is pretty much inevitable. What's different that we have here is that we don't have a single unifying consumer privacy law. There's no federal law that governs consumer privacy right now, although there is draft legislation under review in Congress. There's also a patchwork of specialty privacy laws. There are federal and state laws addressing children's personal data, federal laws addressing different industries such as banking, lending, and education, and then the numerous, at this point, state privacy laws, each of which is slightly different from the rest. The state privacy laws started with California, which was derived in part from the European Union's General Data Protection Regulation, but we had to do it a little bit differently. So each state has its own variations on the laws, and the obligations under these aren't simply aspects of updating a website privacy policy. These touch on most aspects of your client's organizational operations. There are mandatory contract clauses for their service providers that process personal data on their behalf. There's privacy impact assessments, training obligations, and each state does this a little bit differently. And as you can see from the list on this slide, we have about, at least if all the laws under review right now pass, there'll be 24 out of 50 states will have individual privacy laws. Applicability of the laws is determined through a number of factors. One can be global annual revenues. So for example, in California, if you sell products or services to California consumers and you have global annual revenues in excess of $25 million, you can be subject to that law. Much like international privacy laws are extraterritorial aspects of this, so it doesn't matter where your clients sit, it's where they do business. Other factors include the volume of data collected or whether or not your client is a data broker or a combination of those three factors. Next slide, please. In addition, once you start selling products, you're going to have issues related to ensuring that the product claims are accurate and substantiated by reliable scientific evidence, that you're avoiding hot button issues in the United States like greenwashing and deceptive advertising claims. Your clients will be offering products and services via their websites, most likely. In the United States, we have the Americans with Disabilities Act, which typically is thought of for physical retail and office spaces, but also applies to websites. So this law mandates that users that are visually impaired or otherwise disabled should have a substantially equivalent experience of using a website. This is often challenging for web developers who are used to being able to look at and process the flow of the website from a sighted perspective. But there's an industry of plaintiffs' lawyers out there that advocate on behalf of these visually impaired consumers and will file numerous lawsuits. The preparation that you do to prevent this is worth every effort, but it's something that by offering your website in the United States, when you're using these trademarks and selling your products or the client's products, they might become subject to one of these lawsuits. Additionally, there are marketing issues that always have to be addressed. We have federal laws that apply to how email and text message marketing works, including mandatory opt-in and opt-out provisions, depending on what you're doing. In addition, we have a new set of lawsuits going around that claim that unconsented use of cookies, invisible pixels, and other automated collection technologies used on websites violate state wiretapping laws. It's the collection of information surreptitiously without the consent of the consumer. We are getting mixed results in courts on whether or not those are viable claims, but that doesn't stop these plaintiffs' firms from sending out the lawsuits and demanding settlements from clients. So it's something to be aware of and something to address that corresponds, with the marketing and the privacy issues. Next slide, please. In addition, your clients may be engaging in marketing through the use of influencers or other endorsers. Endorsers in this context can even mean their employees who are promoting the products or services, promoting the brand, or customer reviews. So this is regulated not only by the Federal Trade Commission and guidance is under the guides concerning the use of endorsements and testimonials in advertising, but also through state consumer protection laws and enforced by state attorneys general. The requirements here is that there are clear and conspicuous disclosures regarding material connection between the endorser and the brand. So if your clients are giving away products or services for monetary compensation, free products, gifting of experience, or maybe it's even their employees that are posting about the product or about the brand, there is an obligation to disclose that sort of material connection. And it's not just an obligation for the endorser. The brand that's doing the advertising can be held equally liable for non-compliance. So programs and understanding what has to be done on social media compliance is also very important in the United States. When it comes to things like reviews as well, it's very common for clients to want to put the positive reviews for their products and services on their website. These endorsement guides cover, the same sorts of activities here that require you to have a fair and accurate disclosure about what the actual reviews are. So, if you have a product and it has a 3-star review, you can't be posting it on your website only showing 5-star reviews. You have to have that representative sampling that shows that your product lives up to what consumers actually believe about it. All of these are very complex programs. There's a lot of places that your clients could potentially get into trouble. And because we're dealing with not just the federal laws in this state, but in this area, but also 50 states worth of consumer protection laws, getting the advice of your outside counsel on this is very important. Unfortunately, while these laws may exist in your countries as well, the way that the United States approaches it is often a little bit different, a little bit nuanced. So relying on what has been done locally for your clients may not be sufficient in the United States. And that's where we're here to help. And one of the other places we can help is talking about helping your clients bring their employees into the United States and doing so correctly. So I'm going to hand this off to Beth now to talk about immigration.
Thank you so much, David. Yes, so I get the fun topic of the day. Immigration has been in the news quite a lot over the last several years, particularly in the US. And of course, we had the election this week in the United States. There was a lot of concern over what would happen with immigration as a result of a change in regime, which did actually come to fruition in terms of the president-elect. So the big question I've been getting all week is, do we think there are going to be changes or significant changes? Probably not in the context of what your clients are experiencing, what you might be experiencing as a business person yourself, in terms of people coming across the border for business purposes. I doubt much is going to change. The only possibility would be, I would say, on the security front. If you are coming from a country, or a client is coming from a country where there are security concerns, certainly that could tighten up under the incoming regime starting end of January. But I very much doubt that there's going to be substantial change, at least anytime soon, in terms of policy or practice. Let's start off, next slide, with the most common types of entries, which are the visitor entries. Most companies, most clients are going to come to you and they're going to be asking the question, do I need work authorization, if they even think of it? They may be coming to you because they were coming in for quite a while as a business visitor, and suddenly they're being told that they need work authorization. That's not unusual. I have clients who, were coming in for years for business purposes and then one day got stopped. And the big question is always, nothing I'm doing has changed. Why has my ability to enter changed? And the answer really is because somebody said it did. What is permissible? On the left side of the screen here, on that box, you have a list of things that are generally permissible in terms of business entries to the US with just a regular visa, or if you're from a visa-exempt country like Canada, if your client's from there, then they wouldn't need a visa. They would just need to be able to come up to the border with their passport, be admitted as a business visitor. So on the right side of the screen, obviously if you're working with or on behalf of a US company, that's going to be a triggering event that you would probably end up needing work authorization. In some instances, if you're coming in to give seminars or speaking at conferences where you're being compensated in some way, then you may need that work authorization. If you're providing services, excuse me, to a US client of a foreign company, you may require work authorization as well. And sometimes even where you don't require work authorization, it's helpful to have work authorization for continuity of border crossing, just so that you're not coming up against an officer who says, no, this time you can't come in, when you are going down to attend a very important business meeting. So these are the things that we come up against most often. So let's say you are doing one of those permissible activities in that box on the left side of the screen. The next question is, okay, you're doing them, but are you getting paid by a US source? Next slide. If the answer to that is no, then of course you're probably going to have a very simple time coming across the border. In most instances, you might get that officer who doesn't understand the law, who doesn't really understand business travel, and gives you pushback. But most of the time you're going to be okay. If you are getting compensated by a US source, though, that is where you should be seeking some sort of guidance. Again, you could come in for ages, even though you're being compensated, even though you needed work authorization all along, and not find out for years. But if a government official says you need a work authorization, you want to get that. You do not want to do something like, for instance, go to a different port of entry and try to come in because you'll have a different officer and therefore, you might get a different adjudication. You also don't want to go away, come back the next day, coming back to the same port a couple hours later and say, okay, how about now? Because you think there's been a shift change. They have the ability to do something that's not really well known called expedited removal. This is basically an administrative deportation because they feel that they warned you that you needed a work authorization. They told you, therefore you knew you needed work authorization and still tried to come in as a visitor, even knowing that you needed work authorization. A lot of the inadmissibility that we deal with comes from some form of dishonesty or, the legal term we use a lot is moral turpitude. So the concerns come whenever there's any sort of a misrepresentation or you're doing something that you shouldn't be doing because you knew otherwise. Fraud is the worst of them all. It is the worst thing any of your clients can do. That can result in permanent inadmissibility for any reason. So expedited removal itself can be a 3 to 5 year ban typically. So that's bad enough, particularly in the context of business people who are trying to come in to conduct their business, negotiate contracts, come in for sales meetings, come in to speak with or to hire people at an affiliated U.S. business. So we've got to be really careful of that. Next slide, please. But there are lots of ways to come in. There are lots of methods to do that. We try to look at the whole picture, not just a piece of the picture. So we are asking our clients about their short and medium term goals and also their longer term goals. Because if their long-term goal is a green card, then we may very well change our strategy on the short, medium term non-immigrant side if there are various options available to them in order to line them up better for that green card down the road. Obviously, visitor is one category. There are a couple treaty-based visas. One is called an E1 treaty trader. That's where you're doing trade with the U.S. Substantial trade. They're looking for multiple instances of trade over time. Another one is if you are investing money in the U.S. This is where I'm working with a lot of my colleagues here on this call today, because as soon as you're investing in the U.S., you're setting up a business in the U.S., you have to do the incorporation. You have to look out for your branding and your trademark. You have to watch out for all the issues that have been discussed. There's specialty occupation visas called H-1B. These are available to people with bachelor's degrees working in bachelor's degrees positions. There are also intra-company transferees. These are where you have a business or you work at a business outside the US and you've been working there at least 1 year and you're coming in to work for a US affiliated business of some sort. It can be a subsidiary, it could be a parent, it could be an affiliate, it can be a branch. O1 is extraordinary ability. That's pretty self-explanatory. The TN is another, treaty-based, it's USMCA-based admissibility. There are about 63 job categories that you can fit into and obtain a 3-year work authorization, which is renewable indefinitely, but you have to be Canadian or Mexican. And there are other options as well, depending on what you're doing. But those are the ones we most frequently are recommending to our clients and to the clients of our contacts. Longer term, we work with a preference system in the US. Again, I do not see this going away under the new administration. Comprehensive immigration reform has been discussed for a long time across both Democrat and Republican administrations. During administrations where, either the Republican or Democrat has had both houses of Congress and been able to pass law, it has not gotten done. It is not a very popular thing to do, to address, because there is no clear-cut way to solve a very difficult problem, which has really only gotten more difficult over the last several years. So I am hopeful, though, moving into this new administration, that legal immigration will be more facilitated than it has been over the last decade or so. That's what we're hearing. We shall see if that's how it plays out. You can come in under a family stream. Sometimes that's even easier than getting people in under employment-based categories if you have an immediate family member, parent, child, spouse who is a U.S. citizen or a U.S. permanent resident. Sometimes in the process of looking through that, we come up against the fact that actually someone has been a U.S. citizen since birth. Maybe a U.S. parent has transmitted citizenship, and it's real easy to get them work authorization because all they have to do is apply for a U.S. passport and they can come on in and vote and all the rest of it. Potential issues that we come up against are criminal and health-related inadmissibility. Timing issues drive these decisions of the best strategy, costs, goals, and limitations. But one way or another, there's very often an option, particularly when we're dealing with business people. There's almost always an option for those folks. We just have to figure out what works best. And with that, I will turn it back to the team and to the callers for questions.
Excuse me. Thank you, Beth, and thank you to all of my colleagues for your time today. I'm looking at the chat, excuse me, and I don't see any questions, but we'll take a moment. We've got about 4 minutes left, and we can open up the mics. And if anybody has any questions, you should be able to raise them in the chat or online. So I'll just pause for a second to see if anybody has any questions. Right, hearing none. These presentations obviously were very limited. If you have questions that you'd like to raise afterwards, please feel free to reach out to any one of the speakers here today. Beth on immigration is also taking her show on the road. And for those of you who are attending the INTA annual meeting in May in San Diego, Beth will be leading a 1-hour table topic with a more extensive version of this discussion today. So you can learn more by registering for that as well. So with that, again, thank you for everybody who joined today. Thank you for all the participants and for our colleagues behind the scenes who helped put this together. Claire and Janessa, thank you all and have a good evening. Bye.
Thank you.